Okay, there we go. Welcome, everybody. Again, it's a pleasure to be moderating this session that we put together between the TWAILR review, the Third World Approaches International Law Review, and the Masters in Israel Studies at Birzeit University. I'm very excited to be part of this, organizing with an excellent group of speakers. I'd just like to introduce myself briefly. I am my name is Abdelghany. I'm the Murphy Institute visiting assistant professor at Tulane University Law School in New Orleans, Louisiana, but I'm also a research fellow in international law at the Institute of Law at Birzeit University. We have 4 speakers joining us today. Maha Abdallah, who is a PhD researcher and graduate teaching and research assistant at the University of Antwerp Law School. We have Shahd Hammouri, who is a lecturer in law at the University of Kent Law School. We also have Abdelghany, who is an Egyptian lawyer and PhD student. And we also have, finally, Faten Sourani, who is a Palestinian lawyer and Palestine researcher with Frontline Defenders. We have translation, interpretation is available if you want to listen to, we're going to mostly be speaking in English, but there will also be some Arabic. If you want to hear it all in English, just click on that little globe in your settings below and click on the English option. Otherwise, you could click on the Arabic option. إذا حابين تسمعوا باللغة العربية طبعا في ترجمة موجود في الزوم. I think there's I think everyone should be able to see it. Anyways, so what we're going to do is I'm going to be giving our 4 panelists an opportunity to just give their general reflections on the ICJ decision with respect to provisional measures that was decided with respect to the proceedings that were instituted by South Africa against Israel, with respect to allegations for committing the crime of genocide against the Palestinian people in the Gaza Strip. As many of our listeners know, there were a number of provisional measures that were issued. Before going into kind of the specifics, I'd love to pass it around to our speakers to be able to kind of give their general reflections on what those measures said, what they didn't said, etc. It's all yours for about 10 minutes each. And I'm going to start first and foremost with Maha Abdallah. Please, Maha.
Thank you, Ata, and good evening, Masal Khair to everybody. I will not obviously be able to share all reflections so far on the provisional measures issued by the court, but I will share some brief reflections, and I'm happy to discuss more in the Q&A session and go a bit further or deeper into some of the aspects. But as we all have already watched and read, on the 26th of January, the International Court of Justice ordered Israel by an overwhelming majority to take every effort to prevent any acts of genocide against Palestinians in the Gaza Strip and ensure that its military does not carry out such genocidal acts. And there were other measures that the court also ordered Israel to take or to carry out, including to take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance, and to punish and to prevent and punish direct and public incitement to genocide, and to prevent the destruction of relevant evidence and ensure its preservation. And as well, in addition to that, the court also required Israel to report on the implementation of these interim measures within 1 month. So this is what the court, in summary,
Maha,
ordered
I'm sorry.
Yeah.
Maha, I'm sorry to interrupt, but I just wanted to ask the participants to please mute their microphones. Please continue, Maha. I'm sorry.
No worries. Thanks for that. And as many, especially in Palestine and particularly in Gaza, we've seen have been disappointed that the court did not explicitly order Israel to suspend the military operations in and around the Gaza Strip, or in the mainstream language to call for a ceasefire, as also requested by South Africa in its application. And various reasonings have surfaced as to why the court did not do that explicitly, and argued that, for example, the court does not exercise jurisdiction over certain elements that would allow it to eventually call for a suspension of the military operations or for an end of the aggression and so forth. But regardless of the reasoning and whether it holds or not, serious questions arise as to the effectiveness of such preventive acts by the court in light of previous decisions on similar yet different cases before the very same court, and where it has ordered or issued a measure to stop the military operations. And considering also the gravity of the situation as also recognized by the court itself. The court did recognize the urgency of the situation by having had issued the measures within 2 weeks' time since the oral hearing, and throughout the language, the substance of the provisional measures themselves. And but such frustration and disappointment do not really arise simply because of a lack of knowledge of the court's jurisdiction or precedent or otherwise, as I have personally seen some colleagues in the field argue that people are frustrated and disappointed simply because they don't know enough. I think the reasoning behind such frustration and disappointment is also because at the end of the day, this is a result of decades and decades of repeated failures by the international justice mechanisms and system to afford Palestinians justice, rights, and against the backdrop of an overall imbalanced and politicized framework of international law. It led to a point where there is little to no faith in these instruments, also in light of Israel's repeated and deliberate failure to abide by them and the lack of enforcement mechanisms. And the frustration and disappointment become even more valid in this particular instance, considering that what is at stake is the survival and existence or not of 2.3 million people in Gaza, but also the wider Palestinian population and people. So in this case, if people, especially those who are directly subject to genocidal acts, see and feel that the court has not really lived up to the expectations and the needs, then perhaps the practitioners, the books, the courtrooms should listen closer and adapt accordingly. And here I'm thinking about the questions that constantly arise about the ICJ's role, but also other United Nations bodies in the effective prevention of atrocity crimes such as genocide, whether it's in Palestine or elsewhere, especially in the most critical and urgent moments, like the one we have been witnessing in the Gaza Strip for several months now. While we've seen over the decades that there have been clear efforts directed towards the prevention element in atrocity crimes, especially in the aftermath of the Rwanda genocide, but the United Nations organs are repeatedly failing over and over again to prevent international crimes, including genocide, the crime of crimes. But nonetheless, and despite all these shortcomings and all these questions and frustrations that come together, it is important to remind of other elements and ramifications of the provisional measures. The ICJ made it very clear that the South Africa case is not without merit, contrary to what Israel and several of its allies have argued and continue to argue. There are plausible claims that Israel is violating its obligations under the Genocide Convention, that the rights of Palestinians are being violated under the Genocide Convention. And basically, Israel is finally on trial for genocide, and this time for its actions and omissions against Palestinians in the Gaza Strip, which South Africa rightly argues and places as part of an inevitable continuum. And with such an important recognition of the continuum, there's a recognition of the ongoing Palestinian Nakba, which may also open accountability doors to other instances of Israel's violent aggression against Palestinians that may also possibly amount to the crime of genocide. And also the court recognizes the crime of genocide in its totality in the provisional measures order or decision, as also put forward in the claims of South Africa. So it's not only recognizing genocidal acts, but also conspiracy, incitement, attempt, and complicity in genocide. And these provisional measures are also significant, considering that, as we've all thought and argued over the past 2 weeks, that they may bring an end or the beginning of an end to the open-ended shielding of Israel from accountability in such spaces. Although it is yet, of course, to be seen to what extent such an order by the ICJ would have ripple effects in a positive way in other relevant proceedings and mechanisms, whether at the ICJ itself, in the forthcoming advisory opinion, or the International Criminal Court, or within domestic courts, or otherwise. And of course, most importantly as well, the court finding that prima facie risk of genocide, it's not only that the respondent states that have to comply with the provisional measures ordered, but there's also a duty on third states and states that are party to the Genocide Convention to prevent and suppress genocide when the risk is so clearly demonstrated and stated by the highest judicial body of the United Nations. They must refrain from any acts that might aid and assist in the commission or omission of genocide. And lastly, I would like to end on 3 notes. The first one being that any critical reading of the court's provisional measures is by no means a way to undermine the brilliant case and arguments articulated by South Africa before the court invoking the Genocide Convention. And if anything, these reflections, they only expose, once again, the shortcomings and limitations of international law, its instruments and bodies, so that we're able to overcome them. And the second point is that there is no doubt that the decision itself will have implications for years to come, whether beyond Palestine and the Palestinian people, and extending to the wider system that we're working with and dealing with of international law and the framework of atrocity prevention and so forth. And lastly, that there's also no doubt that since the provisional measures have been issued by the court, Israel has continued its genocidal aggression without hesitancy, and Palestinians continue to be bombed, killed, deliberately starved, and deprived of water, shelter, medicine, and other essentials while being forcibly displaced and transferred. So the genocide is ongoing despite the court's provisional measures. Thank you.
Thank you, Maha. That's we really appreciate the breakdown of the provisional measures and how it was approached. And I would love to move over now to Shahd to explain a bit her view of the provisional measures and her reflections on what took part in basically a week since.
Thank you, Ata. And I have to, just give a little bit of warning for those who are listening in English to turn on the interpretation in English, as I will just start off a little bit in Arabic and then I'll go back to speaking in English. أبدأ كلامي باللغة العربية لكي أدخل على النقاش خلفية المشاعر الغاضبة والحزينة التي تغمر قلوبنا في هذه اللحظة، التي نشهد فيها أكبر المصائب التي حلت بنا. أبدأ كلامي بدعوات بالسلام لأهالينا. أبدأ كلامي بالتأكيد أن القانون الدولي كان بالأصل لغة المستعمر، لكننا هنا أنا وأصدقائي الكرام لكي نصيغ من لغة العدل ما يسمح لنا مواجهة العالم الغربي بدورنا الصغير في صراعنا الجمعي الطويل. كان لابد أن أبدأ بهذه الكلمات كي لا نبتعد عن الواقع الذي نراه. It was important that I start with these words, and hence I go back to English, and I thank the interpreters for a wonderful job. As what we see in front of us is something that we haven't really lived through in our common history, let's say, at this level of violence. And it's quite surreal to have spent the last few weeks throwing around the word genocide as we're quite distant from it and put in this very weird positionality. And it's very weird being people who could perceive that pain in its depth and yet have to speak the desensitized language of international law. And perhaps this was the rationale behind this panel that I'm very grateful happened with everyone here being very sincere and close to me. How can this judgment be perceived? And given the words that I just started with, I will start with how it looks like internally. Internally, the word that was used by the court, as Maha has started to tell us, is quite indeterminate. If I may say, it is absurd to come and tell a party that you believe is perhaps committing genocide not to commit acts that it deems genocidal, when that party itself does not recognize that it is committing anything illegal to begin with. It is framing its whole discourse in a whole other language that is colonial in its heart, evil versus good, terrorists versus the civilized. The rhetoric used by Israel is exactly what we saw that mimicked in colonial times. It takes a little bit of reading in history to realize the urgency. So this was no time for indeterminate language that is open for interpretation from the perspective of the people in Gaza, from the perspective of Palestinian and Arab people. This was a time to recognize the bad faith of the other actor of which we speak, and to recognize that we need to have language that puts boots in the ground. And this perhaps opens us up to the bigger problem that we have in international law. In the background of that court, what happened is a try and an attempt to be strategic, not to annoy Western powers far too much by going against the tide and completely taking away the deeply engraved Israeli exceptionalism that we have in international law, especially with the alignment between Israel's position and imperial interests in the Middle East. And at the same time, the court knew that by taking any decision which denies the reality so badly, it will alienate itself and it will put itself at a horrible position vis-a-vis the third world. And it did so back in the days with the West South Africa case, for example, when it committed a horrible mistake that up until today is considered to be a black dot in its history. Also, the reality of the situation at hand and the very strong arguments put forth by South Africa really left no space for the court to negotiate anything outside the Genocide Convention. And yet, what we saw is that the court was able, in such a moment of human misery that we haven't seen, as I said, in a very long time, where we have dead bodies being eaten by cats and fathers and mothers holding the body parts of their children in bags. it shows us, again, the poverty of the language of international law. International law has not integrated thus far the sounds of people who were colonized. The International Court of Justice smelled European, looked European, and acted European, and acted on the memory of Europe, which has guilt over the genocide of the Jewish people, but still doesn't recognize feeling of guilt or remorse for the genocides and for the colonial violence itself committed against peoples across history. That is very clear in the jurisprudence and the precedent of international law. And the state of Namibia very clearly reminded us of that when it spoke about Germany's lack of recognition of its own dark history at the moment when it decided to intervene in Israel's next to Israel, and Germany's lack of recognition for what itself did to the Herero people. And actually, the story of the Herero people is a bit similar in the sense that it revived a very historical colonial practice. And I started to call it in the past few weeks as an eye for a village. And that is when the colonized people rebel in whatsoever way, the colonizer retracts with a mentality of retribution and a mentality of revenge. This is what Israel sees and perceives as its concept of justice. Its concept of justice is inherently built on revengefulness towards the oppressed people in multiple ways. We've seen that in the history of Israel as a settler colonizing entity, but we've also seen that in the history of Britain, Germany, France, and all the different colonizing entities. And the fact that this is not something that international lawyers were able to recognize directly, that forms of atrocity propaganda were something that flew over the minds of so many practitioners in this field, demonstrates to us that this field is still very far off from comprehending the reality of settler colonization and integrating the experience of colonized people. Moreover, the red alert was everywhere in this case. Not only did genocide scholars come out 7 days into the onslaught on Gaza to claim that the red alert should be called in relation to genocide, but the context itself speaks. The context of settler colonization, of a 17-year siege, of a history of consistent ethnic cleansing and displacement, of a far right-wing government whose ideology is premised in the dehumanization of the other. What more could have told us that the people of Gaza are under the imminent risk of genocide? And yet, they remained blind. And yet, we had to wait 3 months to reach the International Court of Justice. And yet, we had to be dealt with indeterminate language. However, there's another perspective from which to perceive this case. And this perspective looks at things in a little bit of a less idealist eye. And perhaps one might say that what I just described is an idealistic aspiration of international law. From an external perspective, outside of the maze and outside of idealism, we can see that on the longer term, this judgment marks the shift of the change in the narrative in relation to the exceptionalism of Israel in international law. One, for the first time, we have engaged the Genocide Convention against Israel. This is big, this is huge, and this can be taken forward in so many different ways. Second, this enacts third state obligations first and foremost, and perhaps this is one of the most important points to be said here. The fact that the Genocide Convention is engaged means that the red alert, means that I will try to put my voice up a little bit for the interpretation. I apologize. It means that the red alert for genocide is now wrong. And it means that third states should be careful to prevent genocide and to prevent genocide, and also to cooperate towards ending any forms of existing illegality in this hand, and to avoid any form of complicity in this genocide. What this means specifically from the perspective of my own work is that an arms embargo is imminent. And as we have learned from the history of South Africa, one of the primary ways to stop grave illegalities of international law is by cutting economic ways of support towards it. The biggest state of the world have historically stood behind South Africa and up until the last moment before they recognized the grave illegality at hand. So we should remember that the only way forward is through enacting third state obligations and through imposing embargoes on different levels that will cut off any form of supply to Israel, which not only has committed genocide, but has also committed the gravest of illegalities in its own occupation that go against the Palestinian people's right of self-determination, the prohibition against apartheid, and the prohibition against aggression in the annexation of land. We will be hearing the public hearings in relation to a parallel case which talks about the illegality of Israeli occupation on the 19th of February. So that will also be a time in the larger shift in the narrative of which we speak. And I will end by also referencing the very shameful position of cutting funds of the UNICEF, which can be considered to be complicity in genocide, since the humanitarian aspect of this conflict is at least one of the primary things that the court has ascertained and has pushed towards recognizing. Thank you very much, and I look forward to further discussion.
Thank you, Shahd. And again, thank you, Maha and Shahd, for very powerful interventions. I'm going to switch over now to Abdelghany. Similarly, 7-10 minutes, would love to hear your thoughts, your reflections on the decisions, its outcomes, and its effects since.
Thank you, Ata. I think the ICJ decision was, one second. Yeah, I think the ICJ decision was historic in many ways. But what is historic about it is not that the ICJ did something so historic and so unexpected. What is historic is the the amount of Palestinian suffering and the amount of Israeli criminality that forced the ICJ to do something unprecedented, which is to associate Israel, a state that has benefited from every single exception in the modern international legal system, to associate this state with the crime of all crimes. What is so significant about the crime of genocide is not that it's the most significant crime, but I think the most significant thing about the crime of genocide is the idea of intent. And this is why the ICJ decision is really important, because now, for the first time, we can talk about intent, criminal intent, in relation to the state of Israel. Now, I think the main challenge to the case, and the main challenge to the case at the ICJ, and the main challenge at the International Criminal Court, and the main challenge in general to address any Israeli act, is basically that there is a deeply embedded bias in the international legal system, whereby states are always assumed that they are not intending criminality, and that it's always either incidental or a mistake, etc. This bias is much, much greater in the case of a modern liberal state. So at the moment, Israel has the reporting obligation. What will happen with the reporting obligation in a couple of weeks, I think now? The answer is absolutely nothing, because this is what states do. States write reports. They're good at that. And I want to step backward. I want to take a step backward before talking about a state like Israel, a modern liberal Western democracy like Israel. But even states, I mean, today we have Myanmar writing reports. You have Syria, Bashar al-Assad. You have North Korea speaking the language of international law. North Korea accuses South Korea of using human shields, of using the civilian environment as human shields. Bashar al-Assad does the same. Egypt's Sisi does the same. So everyone now, every state can really speak the language of international law. Saudi Arabia spoke the language of international law on human shields and urbanization of armed conflict in its intervention in Yemen. So states do that. That's what they can do. They can speak the language of international law, and they can write reports, and they can wear suits. Israel is not just a state. Israel is a modern liberal democracy, Western democracy. So what will happen with the report is that Israel would write an amazing report. Amazing report. And this is really the challenge with the reporting requirement, and the challenge with the case in general, which is that basically there is a deeply embedded bias in international law towards the state, and specifically the modern liberal state, whereby, now to go back to Shahd's intervention, when she was describing the images that we see coming out of Gaza and West Bank, this bias makes basically any image meaningless. Whatever you will show me, international legal language can possibly interpret it as lawful and consequently desensitize us to it, as basically as necessary, as incidental, as a mistake, etc. Literally any image. And that's why today you have any US spokesperson answering the question whether how would they comment on the footage showing live Israel sniping civilians. They would always say, I don't have the information. We've had footage showing AP photojournalists being shot, and there was no crossfire or anything. But we always need to wait and see. Of course, imagine if a non-state actor has been captured live shooting at journalists in a situation where there's no crossfire. No one will wait and see. Already you have 7 October, the operation in the morning, already by noon time, it was legally categorized as an inherent atrocity by progressive legal scholars, by the way, who are pro-Palestine. So I think the main problem with the challenge, the main challenge with the case, how it will go forward, is that Israel will always push its own laws of war that we have seen in writings by the Israeli moral philosopher Asa Kasher, and we always see the writings of Aaron Barak and his dissenting opinion. There is always the idea that I would like to call it the trust me bro Yusin Bello. There is the idea that I'm a democracy, trust me bro. This is really what it is. And this is really, I think there's a massive role for critical scholarship today. I mean, really, what a good moment for people who didn't like the legal curriculum at the law school, and who were like, no, I don't like that, and decided to go for critical scholarship. What a good moment for them to be alive. This is really the moment where you don't talk the conventional legal language. This is really the moment where we need to be critical scholarship has a massive role, but of course, always to frame it in legal language. Always it has to be like that. So for the case to go forward, we don't need to talk about human shields in terms of evidence only. Of course, we need to say, well, Israel, where's the evidence, etc. But the main issue really is, this is the role for critical scholarship in basically showing that how the Red Cross, the International Criminal Court, in all the policy meetings it has, and all universities, whenever they talk about human shields in modern, in contemporary armed conflict, they talk about it as a phenomenon that is the result of contemporary armed conflict. It's the result of an asymmetry between the weak and the strong. And it leads the weak party to urbanize armed conflict. We need to tap on these issues. We need to talk to the ICRC and say, well, ICRC, now you say urbanized armed conflict. Let's talk about your bias in considering this a challenge to international humanitarian law and not a challenge to the modern liberal state. Because once you talk about the human shields framework, you already have the position, the standpoint of the modern liberal state that is trying to conduct warfare in the civilian, in the urban environment. The first time this was challenged was in October the 7th, where the modern liberal state was for the first time in the defense position. In this point, because we trust Israel, no one spoke about Israel potentially using its own people as human shields. Israel today has pledged 20,000 shekels a month for families in the vicinity, living in the kibbutzim in the vicinity of Gaza. This is about $5,000. Israel pledged this amount of money, which is a massive amount of money, to these families to go back now. But no one would speak about that as potentially human shields. Now imagine if the Palestinian armed groups promise Gaza people, Gaza Palestinians, to go back to the north of Gaza and offer them money. Of course, everyone would talk about that as human shielding. So really, now is the moment to deconstruct this narrative critically, and to start. We will never get a positive decision from the ICJ or from the International Criminal Court. International Criminal Court views any Israeli attack as Israeli or American or British. If you read the Iraq or Afghanistan reports, it's always incidental. There is even when the prosecutor is really taking the right way, they're always talking about proportionality. The idea of willful killing cannot be thought of in relation to a modern liberal democracy. Why? Because to talk about a willful crime and to talk about a crime as part of state and state plan and policy, or crimes against humanity or genocide, we must be able to paint the image of this potential perpetrator as an inhuman human, to talk about it as an atrocious actor. Until now, we are not able to do that. And this is why we will only be talking about disproportionality or like this kind of crimes. This is the maximum we can get from the ICC. And to get a positive decision from the ICJ, or to get Karim Khan to do anything meaningful, we need to start talking, deconstructing the human shields discourse, and start basically painting the Israeli high-rank official as an inhuman human who can be atrocious, just like people who are from our countries. They can also be atrocious. So, yeah. Thank you.
شكرا عبدالغني. أنا معك يا برو. والله I completely understand. I get it. And I think many of us are seeing it the same way. Last but not least, we're going to move to Faten Sourani. Faten, I look forward to hearing from you for the next 7 to 10 minutes.
Thank you, Ata. And thank you, everyone. it's a privilege to be here with you today. It's not every day that we see something like this. So thank you to the organizers, and thank you all for arranging this. On this note, I just maybe wants to start by saying that it takes a lot of bravery and a lot of mental space for the brilliant colleagues today to do this. And I just want to recognize this. And I think it's important to mention how consequences for the speaking out against Israel are not surprising to anyone following what's happening. And people like us who speak out have to think of themselves, their families, and people around them when they speak about Israel and the atrocities committed in Gaza. In my position as I work with Frontline Defenders, as Alpa mentioned, we have documented so many cases of consequences and retaliations against human rights defenders. This includes, of course, journalists, human rights lawyers, medical workers who speak out on the genocide, and also a lot of people that faced all kinds of consequences, including killing of their family members, being imprisoned without charges, or being forcibly disappeared. And this doesn't only happen in Gaza. We can see the imprisonments and prosecutions happening on a large scale in the West Bank. Colleagues at Al-Damir organization in Palestine, they documented more than 5,000 cases of this happening. So I know speaking out doesn't come lightly, and this is a lot, needs a lot of reflection on censoring Palestinian voices in the legal, international legal spaces, and also the effect on self-censorship that we cannot deny. So yeah, I thank colleagues for the courage. I thank you for the brilliant inputs that you have already put forward. And perhaps on another note, I couldn't also, before touching the ICJ decision, I could touch on the censorship that also Palestinian voices and Arabs face on the international legal spaces, and how little space we have there to express our opinions. And it's not a surprise, it's a trend that has been going on for a really long time, and it's recognized in some spaces, that Palestinians, Arabs, victims of atrocities and occupations around the world do not really get to say their legal opinions. They don't get to be experts. We get to be the subject of international law at most. If you're lucky, you can be considered victim. But it's hard for you to be an expert and have a legal opinion. That's not your space in the world. And unfortunately, we don't see any movement to reverse that from the legal, international legal practitioners or lawyers, but it's further enforced by the detachment and practitioners choosing not to talk about it, or for fears of labels, or intervening Palestinian voices for fear of being viewed as a pro-Palestine. And yeah, I think this is a major issue that needs reflection. Yeah, I'll stop there with it. But on the ICJ decision, I join colleagues in saying that this is a major moment for Palestinians, for the accountability on the decades-long impunity that Israel has been enjoying, an impunity that facilitated a lot of its crimes against Palestinian people with no consequences whatsoever. It's not usual that we see Israel, or never we see Israel put on the bench and prosecuted for a crime like genocide. I think it's a huge moment, and I join what Maha said about the frustration of Palestinian people and people in the region on the provisional measures that's been pronounced. It's still great but disappointing. And I recognize that people's frustration and it's of course not coming from lack of understanding, as Maha put it, but of course from decades of no accountability and basically no faith in the international community and the international system to actually bring justice to Palestinians. However, we remain expecting much from the system because we believe in the justice of our cause. We continue to face these crimes and we continue to suffer as Palestinians. So we still expect a lot from the rule-based international system, but our hopes are pretty low and due to the history of Palestine in that space. So yeah, definitely a historical moment, and if I maybe could just put some reflections on why it's significant, I would mention, for example, the effect that this decision could have on emboldening and strengthening the different and many strategic litigation cases that we could see around the world, those in the US, but in other places. I could think of the case that Glan and Al-Haq brought in the UK for the arming and the legality of the continuous supply arms to Israel. But also the very recent decision on a case in the US that was dismissed, I believe, yesterday. And although it was dismissed on jurisdictional basis of a political question, I believe it's the federal judge went the extra mile to say that, to mention the ICJ decision and to also talk about how the crime of genocide and how the US and the Biden administration could be viewed as complicit in that crime for aiding and abetting. So definitely, even if we don't see effect on the ground already, because as colleagues mentioned, since a week ago, when we see the behavior of Israel on the ground, it does really show lack of listening to the provisional measures. We see a disregard and Israel thinking it could do what it pleases. Of course, with the pack of its allies, like the US, that said, our foreign policy is in line, and what Israel basically said about them basically doing what the court has already said that they're doing. So we saw thousands people killed in the past week. We saw moves to widen their military operation to Rafah, where a lot of people went to and relocated as a safe area. Although that the effect on the ground, we're not seeing it already. We see very sadly inadequate responses by states, not recognizing their responsibility in this regard. But I do personally hope that the pressure would rise on these states and also on Israel. It still is a reputational blow for Israel and also the other allies. And in general, I would just add in the end that from the legal discourse, it's important that we have the genocide now to describe the whole of what Palestinians in Gaza have been experiencing so far. It adds to the framework of apartheid and the last decade of international advancement in the international legal discourse. If we are going to talk about the ICC and Palestine becoming a member state, and if we're going to talk about the apartheid and how, you know, that was a great qualification of what's happening to Palestinians on both sides of the Green Line, and now moving to genocide. And I think these words being connected to Israel's name really moves us away from seeing Israel as Shahd put it, in an exceptional way in international in the international legal spaces. So definitely, I think it's a significant moment. I'll stop here, moving to the questions and answers, and maybe put more words there. Thank you.
Thank you very much, Faten. Before I will be taking some questions. We have about half an hour left. I did want to, there were a lot of interesting points that have been raised so far by each of you. Issues related to the ICJ's possible restraint, issues related to cutting off funds from UNRWA. There's just a lot going on. And I think one of the first question I want to ask is, and this is open to all of you, and I ask that you keep your interventions to about 2 minutes so that we can get some questions in from the participants as well. Is there a sense that the ICJ restrained itself, that the ICJ restrained itself for reasons that may be political, because of, as Shahd mentioned, it, you know, it looks European, it acts European, it is European, right? Or because there is this other, you know, set of proceedings that's going on now at the with respect to the legality of the occupation, the advisory opinion, or maybe that they just don't want to look like a court that can make very bold statements and nobody really listens to, which kind of weakens the credibility of the court. I'd love to hear, or something else. I'm just taking from some of the ideas that I had and that you had each mentioned. I'd love to hear your thoughts on that question in terms of the ICJ and its restraint. And whoever wants to jump in, please go ahead.
If I may. I've been going around the past few months trying to talk about the politics, international law junction, and people who go into law are usually thought of to be the people who are supposed to think about the question of justice, However, it takes 1 year into law school to find out that really this is not about the question of justice, but rather about the question of what is law. In international law, I always say that it's very insecure about the question of justice, because international law is not, there's no state that is enforcing that law on people. So it has to establish its international legitimacy on some premises. And if you read the UN Charter, you'll find these vague references to justice. Even the International Court of Justice is named after that. So international law sells itself, legitimizes itself by a claim to justice. However, it itself knows that in the making of international law is inherently politicized, and so is its practice. However, there are moments when justice is just so much there in your eye that the system breaks, so to speak. And there are historical moments, for example, in the 1970s, when the UN, for example, stood against South Africa, apartheid South Africa, or when there was the new international economic order and the like. There was a lot of movement at that time. Even when you look at the case law of the International Court of Justice at that time, you find very strong language, like, for example, Judge Fuad Amoun was talking about the people's right of struggle against colonization. So now we're seeing a change in the political domain. We're moving from I believe what people are saying is a unipolar world to a multipolar world. And two, the case of the Palestinian people is so justiciable in your eye that the indeterminacy of international law cannot hold. And I think that this was very clear to the court. And yet they went with absurdity in their attempt to kind of balance politics and justice. And what we are hoping to do with the case of international law is to put it to shame, to put its own logic to shame. Because if we are to think of the basic premises of human existing, such as, equality and egalitarianism, such as the protection of childhood, very basic tenets, Israel has been in contravention of those for 75 years. So the accumulation of injustice is so horrible, it's so heavy that the political tendency at some point or another will have to crack down. And now we are within this negotiation somehow, actually, of what reading of international law will we opt for. And again, if I may stress what Faten was saying, this is the importance of having a panel like this, where actually the critical voices who are closely familiar with the position of the subject affected by international law in this case, are able to put that logic to shame. And that's why it's very important to have these voices heard at this moment, so that we won't be facing again so that we will continue the push. So I always tell everyone, don't put that much hope into it, but the system is crashing. And the more we put it to shame, using the language of justice, and the more we're reminded that its own legitimacy is at stake, the more we're able to take this forward, not making international law completely our own, but putting international law completely to shame, as it already is with relation to the case of Palestine. And perhaps this is what we saw, or let's say that's a little bit of the tension that I feel was present at the background of the International Court of Justice.
What you just said reminded me of those who know me have probably heard me say it, and because I can't forget, it reminds me of a European scholar one time who once told me, do you think you should be, because you're Palestinian, that you should be speaking on international law issues related to Palestine? It was talking about the occupation. Automatically, I was removed. I was no longer a credible It was no longer credible. So sorry, Abdelghany, you were going to say something as well, with respect to the issue of the ICJ and its possible restraint, with respect to its decision on provisional measures.
I was going to say something, but but now you made me think of something else, which is the last point you just mentioned, about your voice being automatically excluded. It's amazing how after this UNRWA, the lawfare on UNRWA, it's 100% the lawfare campaign. How this campaign resulted in suspending the funds for UNRWA, because of the claims that a few UNRWA individuals participated in the October 7th attack. Whereas, I worked in the office of the prosecutor of the International Criminal Court, and we have former Israeli army advisors and officers and US Army, and they work, and this never prevented them from working on situations that are not about the US or there is on situations that are not about the US or the Israeli conduct, because of course the court and also prosecutor is very objective. You cannot work on a situation that relates to your country, but the US is involved everywhere. But somehow an American jurist, probably formerly served in the US Army, can work on any situation in the International Criminal Court, presumed to be professional and objective, although the US is the world police. It's involved everywhere. Why is this? Again, it is because there is a bias against the non-state actor. And as a pro-Palestinian scholar or lawyer, you're a pro-non-state actor in a way, and the bias is much stronger if it's a liberal state that we're talking about. So this takes me to the point. I will finish quickly. This takes me to the point about the ICJ constraints. I think the ICJ had to say what it said. It cannot say something else. Why? Because if the ICJ orders the Israeli army to cease all its military operations, it means that the ICJ thinks that the Israeli military campaign in itself inherently is a genocide campaign. The court cannot do that because the modern liberal state and the modern state, but specifically the modern liberal state, always benefits from the right to the benefit of doubt. Again, to the, trust me, bro, laws of war, jus in bello. So the court cannot say that. In the Russian case, the court could say, Russia, stop all your military operations, because the crime we're talking about is not a crime of genocide. Russia is accused of misusing the Genocide Convention to commit an act of aggression. So to order Russia to stop all its military operations is to assume that any single Russian bullet in the Ukrainian territory is part of a crime of aggression. But to order the Israeli army to stop all its military operation, it's to assume that any Israeli bullet is part of a crime of genocide, which the court can never do. This is crazy. The court would never be able to do that. Whereas on the other side, if the Hamas, for example, was a state actor and its conduct went to the International Court of Justice, the court would be easily ready to consider 7th of October inherently atrocious. In this way, the court, towards this, the court would easily be able to recall irrelevant and relevant historical and contemporary context. They would refer to the 1987 Charter, which is obsolete. They would refer to these crazy statements that have specific religious meaning. It's not a political meaning, but they would recall all the context. They would never recall the context of Theodor Herzl in relation to Israel, which is a state that, the state itself has to remove the people. So there is a bias to the modern
Yeah.
liberal states that prevents the court from ordering cessation of all military operation?
It reminds me of something I've spoken to at length with a couple colleagues who are here in this room, is that everything that people from the global South say is kind of taken at face value, right? But whenever it's from the global North or allies or whatever, there's always the question of, that's not what they meant, or we need more. What else can that's not really what they meant. They meant something else, but for some reason they automatically know what the Arabs mean. I find it fascinating. But you bring up a lot of very interesting points, and we have about 25 minutes left, and I'd love to, if anybody does have questions, I'll try to take them within the time that we have. But I do have a couple of questions myself, just to kind of close a couple of gaps that I see.
Maha has her hand.
Maha, please go ahead. I'll ask right after you. Yeah, please go ahead.
Thank you. I just wanted to come in on the question of whether the court restrained itself or not. And the way that I've been thinking about it is that the court recognizes a lot of things, a lot of valuable and valid things in the provisional measures that it delivered. That one party is possibly committing genocide, it recognizes the catastrophic reality and the outlook of this reality becoming worse by the time a decision is delivered. So the court itself recognizes these. And again, it recognizes the urgency of the case and the situation, yet it still limits the order to preventing acts of genocide, which but not the suspension of military operations. And there could be varying reasons, again, for this, whether the argument of, or the court not wanting to go into the argument of Israel's right to self-defense, or its jurisdiction or lack of it over non-state actors and whatnot. But again, it shouldn't be very difficult for the court to find this jurisdiction to order Israel to suspend military operations, and to draw the line between genocide of a people and a settler colonial state's, again, right to self-defense in this very particular instance, and especially when it's very clear who it's claiming to defend itself against is the very occupied, colonized nation and people that it has been occupying. So yes, I would think that the court did exercise some sort of restraint in the orders that it has delivered, and that it could have found the necessary jurisdiction in order to explicitly order not only for the prevention of genocidal acts, but the very same military operations through which these genocidal acts are being carried out.
Yeah, I think you hit the nail on that one, is that, the court could have clearly made its reiteration on the fact that Israel does not have the right to self-defense in occupied territories. My concern there is generally that they didn't want to go into the law on the conduct of hostilities because they felt that the Israelis would run away with it and start using it to justify the quote-unquote self-defense argument. But they did that anyways, so it made no fundamental difference. They found a way to the government found a way to twist the language. Abdelghany, I don't know if you have your thumb up or a hand up. Okay, thumb up. Okay, good. To something that Maha said, but it brings me to another. There's so much I want to cover. We're not going to be able to cover it, but there are a couple of things in particular based on some of the things that you mentioned, and UNRWA was one of them. And it just seems that so convenient that this was brought up around the same time as the ICJ decision. It brings up the issue of plausibility, as Abdelghany has spoken about, that the genocide is implausible to the West, but these allegations without much to work with are suddenly plausible, but also it gives this kind of excuse almost, is that we have this obligation from the provisional measures to ensure humanitarian aid and access, and you just moved or completely stopped one of the most significant actors in humanitarian aid and access in the Gaza Strip, so that come reporting time, I understand my obligations, but there's nothing I could do about it because UNRWA. I'd love to hear your thoughts on the various aspects related to this, the shifting of attention, humanitarian aid and access, as it relates to the ICJ opinion, and what it might mean for the ICJ to say clearly, as we've seen, that humanitarian aid and access is a failure in the Gaza Strip. Anybody?
Then
I see Abdelghany. Please go ahead.
After Shahd.
لازم بقى يلا. I wanted to say, I think what Gani described it before as lawfare. I also describe it as economic duress. And this is a classic move by the coalition of settler colonial entities that run our world in their conception of the world status quo as we live in the world that we were been living in the past 20, 30 years. What I mean by that is, for example, when I mentioned in the 1960s and 70s, states of the global South tried to change the narrative. And directly what economically advanced states did, it was very obvious that what these guys were saying was very logical, justiciable. We want sovereignty over natural resources and the whole lot. But then with the Thatcher and Reagan regimes, what happened was a push towards the debt crisis in Latin America, economic squeeze on multiple countries. So it is a classic colonial logic. Whenever this global South decides to rebel, and we can understand this move by South Africa to take this case to the court as a rebellion by states of the global South, and trying again, as I said, to put that logic of politics to shame. And the direct answer historically has been to use their economic privilege as a form of economic duress in order to ensure that their position stays. So it's like, well, you guys are rebelling. Who the hell do you think you are? It's our system. We built it and it will work for us. We've seen that historically. Yeah. This is how they repeated themselves, and it's completely horrible to see it in action. But actually, just one last note, one of the failures of international law is that we don't have a word to describe or conceptualize and understand economic duress when it's right in our faces. And I think that's a huge problem that really needs to be discussed, because economic duress is a very big problem to state consent, and state consent is at the heart of international law. So what fictional world are we talking about here, where we just make up, where we just evade real politics?
Yeah, Abdelghany.
I want to make two quick points on UNRWA. The first one is a positive point, which is, I think this is a good moment to appreciate that we are lawyers for once, because basically the unsubstantiated claims that run wild in the chaos, in the informational chaos that is taking the whole world now, this kind of claims don't have any currency in a court of law. So the claim about UNRWA and all that, Israel will pay for it, and there is room. And there is room for even moving against other third party states, because the claim about UNRWA is ridiculous. So this is a good point. This is positive. The negative part is that I am afraid, this is to add to Shahd point, I'm afraid that we are now in witnessing a moment where basically the institutions of the post-World War II global order that were made to sustain the colonial power structure and ensure so much colonial continuity in today's world, I'm afraid that now that they're starting to threaten, the former colonial powers. Now the former colonial powers are basically just trying to dismantle the entire legal system. So now we are stuck between two kind of politics. We have the Trump, Le Pen, Meloni, like these kind of crazy guys, and Nigel Farage, etc., who want to destroy the world now, all its institutions, the entire global order. They want to destroy it. Today we have UNRWA, tomorrow WHO and UNICEF, and of course Karim Khan, International Criminal Court, is waiting for its turn. Trump will make another massive crime attack against the ICC, whether Karim Khan does something or not. Of course, Karim Khan would never do anything sufficient, but even if he does or doesn't, the International Criminal Court is about to suffer another massive attack. So you have these crazy people who want to destroy the world anyway. The other problem is that the other side, we no longer have Tony Blair. We have Rishi Sunak and you have. But we no longer have Obama. We have Biden and Hillary Clinton, who also want to destroy the world, but slowly. But this is a big risk. They want to destroy the institutions that are sustaining colonialism, just because now, for a single moment, they're destabilizing their power. So, yeah.
I think I would like to go into the ICC, but I think we need a separate session altogether on the ICC and Karim Khan. I do want to ask another shift a little bit with the time that we have left. What we have the provisional measures, but we still have, as Faten was explaining, the complete destruction of Gaza. We're still seeing for Palestinians. We have access to all these videos. It's hard for us to not look. We have to look. And I wonder, and this is to, I'm sorry to put you on the spot, but Faten in particular, I'm curious. What does it mean to go to Gaza? I've been there several times. I saw the destruction after 2014 in particular. And even thinking about that, I'm afraid, not concerned, I'm afraid about what it would be for me, who has just seen it. What would it be for you to go back and see what has occurred?
Thanks, Ata. I mean, not to make it personal, but yes, I am a Palestinian from Gaza Strip. I am not based there currently, but my family members are there. And what I do think of now is really not, I don't feel like we have the privilege of yet thinking about, going back and visiting and seeing, as are all Palestinians in Gaza or those who have family there, thinking of their survival at the moment. Will they survive this evening, this night? As nights are the hardest, as we all know. So it's been an ongoing nightmare for 100+ days. Every evening we're thinking if they're going to survive the next one. I personally lost family members in this ongoing genocide. And yeah, to answer your question, um, I really don't know if there is gonna be anything in Gaza to go back to. As we see now, and as we hear from people there, you don't. The infrastructure is destroyed. There's no streets. There's no universities or schools. The houses, if it's not damaged, it's completely destroyed. This didn't stop. 2 days ago, there was a whole block in Gaza City that was completely bombed in seconds for no apparent reason. It is ongoing. The destruction is ongoing, and it has been said by Israeli politicians at the beginning. The aim is to destroy, so they want to have no habitable life in Gaza. They wanted to go there, and I do personally believe that this didn't start when it comes to Gaza. This didn't start on October 7th, as we all know, but more specifically on the whole, voluntarily relocation specifically. If we're talking, we need to see this since the beginning of the siege. We need to see what has been inflicted on people in Gaza to actually force them to want to leave, which has been the plan all along, I believe. So people really, it came to, I don't want to go so much in details, but really people now really want to leave. They lost everything already. They lost their houses, they lost family members. They only have their life to have now. So if we really don't see a halt to this brutal genocide that's ongoing in Gaza, just really can't blame people on following the Israeli plan for voluntary relocation. Yeah, so I genuinely hope that we can see mounting pressure, political pressure in the coming days. I don't want to say weeks or months. Hopefully this we don't see an end to it, but we hope it does end soon. And we hope that that putting the eyes of the world in Israel now, and the great attention that the ICJ decision has gathered, will actually move Israel not to move forward with these plans that has already been said publicly. So
that's the fear, right? Just the reality, to make a place that you can't go back to, right? Nothing there, no infrastructure, no nothing, just complete death and destruction. And it brings me to the last question. If anybody does have questions, please write them in or raise your hand and I'll take them right after this. Because it ties back into what Shahd spoke about earlier, as Palestinians being the subjects of international law. And I followed very closely and seeing how many people were, including our own scholarly community, as part of the reasons that I put us together, I put the Arabs together for this, was because of the silence that existed. We saw it coming, but a lot of people people that we know, that we've worked with, didn't speak out. Maybe because they didn't feel a need to, maybe because they were afraid. There wasn't much to say. And then finally, with the ICJ, you see people talking about, they're finally engaging with the topic, but the victims were like a moot court, right? Just an afterthought. They're just there. And by all means, they could be replaced with another name and they'll be treated exactly the same. And there's this failure to engage Palestinians and Arabs, but a willingness to engage those individuals on multiple occasions that hold the line of the Israeli government, who have been retweeted by the Israeli government. And it kind of reinforces the fact that the legacies of colonialism and imperialism and international law are still existent, which goes to the title of this. I would love to hear your thoughts on some of those criticisms and contradictions. Please go ahead, Shahd.
Thank you for that, Tata. And we have been I've had conversations for the past few months, and multiple thoughts come to mind. First of all, what has happened has been a type of one conversation about Abdelghany. It's been a type of a test to see one's moral positioning capacity. And it has shown us the level of dehumanization that we have been talking about, and desensitization about people who have built their whole careers talking about wars, states, people, and human rights, and then are incapable of recognizing things when they see them in their faces. And as I said, we have a very clear problem of putting aside colonial perspectives and making that marginal to the discipline. You're a great international lawyer if you have the patience to study the positivist logic of its all of its rules, and to be honest, from a Palestinian perspective, from an Arab perspective, from a critical perspective, that patience is beyond me. Because international humanitarian law is very outdated. The reason why it's outdated is because economically advanced states, as Abdelghany was saying before, we're going against it. It demonizes non-state actors. And for the past 10 years, and specifically with the war against terror, Israeli and American lawyers have rose to the stage to create their own reading of international law, international humanitarian law, that builds on a very Liber code type of ethos. And that kind of is, well, you have a just war, and whatever means you can do to protect the civilized nations around you, you're fine. And then with the introduction of the terrorist framework, because of the fact that a lot of colleagues, even who are liberal and colleagues who recognize themselves on the left, have been so deeply saturated in that reading and normalized in it, they were not able to see how blind they are to the de facto humanization, which is why I felt the need to start this panel with the recognition of the amount of pain and emotion that comes out of that. And actually have been putting forth the need to actually listen to the subject affected by international law as a point to comprehend this discipline, because most of the people who are in this discipline are either European in actual race or in perspective and education, and also quite very privileged, have never been under the direct risk of being bombed, which is why you see all of these blog posts where people are able to negotiate how do we kill the people of Gaza, and how far can we go with this and that. I don't think they realize the violence, and I'm sorry to use this academic word, the epistemic knowledge level violence that they don't realize. But if I may just also say one last point, which is the other problem that you have with the Arab silence. And the Arab silence is, again, a huge reason of why we held this. It's not only are we deprived of our voices internationally, but we're also deprived of our voices nationally. Governments of the Arab world do not represent their people. And at the same time, the space for intellectual discussion in our area of the world has been suffocated. in part because of the history of the imperial interest in the region, but then in another part because of the ruling regimes in that, which have meant that we are also looking at intellectual deprivation that hasn't allowed us to take hold of this story and take hold of international law specifically and speak it as agents, which is why it is very rare to find critical Arab voices. It is often that you find international lawyers, but it's very rare to find those who go the further step, the step that was there in the generation before us, with Bassiouni, with Abi Saab, with Bejawi. Perhaps again, I'm an idealist and a romanticist, but I long for the days when that level of discussion that is premised on agency is back, and perhaps this is a moment of collective reflection. Thank you.
Any other?
I can add something.
And sorry, just before you, we do have a question. Okay, great. We do have a question. Just wanted to reiterate that we do have a couple minutes left, few minutes left for a few questions. So by all means, please ask them. We'll try to get to what we can. Please, Abdelghany, go ahead.
Let's go to the questions then. Better, yeah.
But did you want to mention something about the point I made with respect to representation, scholarship, and all that?
Yeah, the point that Shahd was making when she was saying that governments in the global south do not represent the people. This is again the central point why the global south is particularly sensitive to how international law operates, because again, when we talk about the deeply embedded bias against the non-state actor and the privileging of whatever the state does or says, this is in part, this is why the global south is particularly sensitive, because our governments do not represent us. The case of Palestine is extreme, but there is Egypt, there is Colombia, there is Sri Lanka, there is Ethiopia. All these governments also do not represent their people. The reason why Palestinian scholars and Arab scholars need to be given voice is that we particularly are sensitive, and we particularly are extremely suspicious of the state account, because states do not represent us. So the difference between me and my British colleague is that when Israel says there is a list, he takes it seriously. But for me, the state, anything the state says is wrong until proven otherwise. So this is an important reason why Arab and global South scholars need to be given voice and have been completely silent in the last 4 or 5 months, in particular in relation to the idea that 7th of October was inherently atrocious. No one was given the room to speak and say, well, let's wait and see, maybe 5 years, maybe 10 years, and investigate and see what's proportionate, what's disproportionate, what's human shields, what's not, what's killed in combat in crossfire, what's not, etc. You know, when the US killed 400 civilians in a single attack in Al Amiriya shelter in 1991, the whole international community was like, fine, let's wait and see. And the strongest condemnation language was from Human Rights Watch, asking the US to investigate what went wrong with gathering intelligence on the target. So why don't we benefit from this on 7 October? The reason why this is extremely important, because in the Western moral philosophy, everything Israel is doing now is justified and justifiable once we are not questioning 7th of October. In the 19th century inter-European war, in the early 20th century inter-European war, when Germany occupied Belgium, in the World War II, every single atrocity the Germans committed in France in the Franco-Prussian War, every single atrocity the British committed in Germany in the First World War, the biggest genocide and crime against humanity in history, Hiroshima and Nagasaki in World War II, is justified, fully justifiable in Western moral philosophy as a necessary response to an atrocity. So what Asa Kasher and Aharon Barak and Israel's legal scholars are saying today, and moral philosophers are saying, is absolutely the same that Carl Schmitt said and that Oppenheim said. It's the same, it's identical. So we need to be able to question October the 7th, but we were never given that ability by pro-Palestine, fully progressive scholars. And that's why I'm not on Twitter.
Yeah, and we do have a question here, and it seems that it's the only question. And if it is, we'll end it after that, about the American stance on the accusation of genocide. I believe Maha, if I'm correct, mentioned the case in the United States, and the issue of aiding and assisting, well, not only not preventing or doing what you're supposed to do to prevent, but also aiding, assisting the issue of political question. And I think the question here, if I'm reading it correctly, is basically what can be done with respect, I think this also speaks to the limits of international law, right? What can be done with respect to third states, the US, and other stances for those that have been directly involved with respect to, for example, arms transfers? Or did the provisional measures from the ICJ really do anything? Is there anything it really adds to the obligations under the Genocide Convention? Is there something else? Yeah.
You may be speaking briefly on the state's duty and obligations under the Genocide Convention. As you mentioned, they're not only limited to not commit genocide, but to also prevent, punish, ensure effective penalties, and that those who have been accused of the crime of genocide in its various dimensions or elements, let's say, are tried in the relevant tribunals, whatnot. But of course, the state duty to prevent genocide as well includes the fact that they should not be actively contributing and aiding and assisting and abetting the crime itself, and this includes financial, material support or contributions to the crime. And as we've seen in the case of the US, but also the United Kingdom, the Netherlands, Germany, the United and a few others where they have continued and perhaps at moments increased their provision of arms or weapons or certain equipment that is used in the arms manufacturing and weapons manufacturing, and then these are used to target and to kill and to destroy and to carry out various genocidal acts. So technically, the provisional measures, as I said earlier, they do not only they're not only necessary or not only binding on the states themselves that are part of the case in question, but they also trigger further or substantiate further the obligations of states that are party to the Genocide Convention, that whether you believe it as a state politically there is a genocide or not, or risk of genocide or not, there's the UN court, the highest judicial organ of the United Nations, saying that there's possibility of genocide, there are risks of genocide. So whether you believe it as a state or not, then you have a duty to trigger immediately and obligations, including to refrain from contributing by means of arms, weapons, and so forth. So in practice, it should be easier to push, or in theory, it should be easier to push these countries to stop their contribution to the ongoing genocidal aggression. But in reality and in practice, that remains to be seen. But I think some countries will and have are in a process of responding to the provisional measures in relation particularly to the weapons and arms relationship with Israel.
Yeah. Does anybody else want to add to that? Yeah. I don't see any more questions. So any final thoughts? And maybe we can go backwards from Faten.
I think one last thought that we have not really touched on is the how the ICJ decision showed clearly the bias in international and Western media, how it really showed the reality of the racist and non-professional reporting that has been happening, especially with regard to not mentioning or reporting on all the genocidal incitement by the political leaders in Israel. I think that's very interesting to see in the framework of genocide, because previously from the casework of different international organizations, you could see media persons being prosecuted for genocide. And I think this really, I don't want to be very optimistic, of course, but it really does put these media outlets on notice to change their behavior that's been happening so far. What something else I would like to say is that on the US and claim on that the judgment is really in line with its foreign policy, I would like just to add that the position of Israel and the US on how they responded so far has been trying to ignore, basically, how I saw it, what the court did actually say. So the court did explicitly said that for Israel's humanitarian assistance effort has really not been sufficient. And it did really also talk about its efforts, as it claimed that there's ongoing effort in prosecuting individual for that incitement, and how also in connection to that, how some legal, especially Israeli legal professionals, try to kind of disassociate this language from the actual military conduct on the ground, and as two separate things. It's really did, the court said that this is not sufficient, and then there's a reason why the court did really order these measures, because it's not being implemented. So yeah, the very shameful position of the US so far, as it's always been. And yes, I will just end up here. Yeah, thank you, Atam.
Thank you, Faten. Abdelghany?
I see a comment about the Jenin hospital raid, that some people try to legalize this. So I think I can close with this, that the reason why I'm Egyptian, and the reason why I'm with Palestine. Of course, there might be biases related to me knowing Palestinian food and music and people, etc. But really, the reason why I'm with Palestine is that I think, yes, of course, someone tried to justify the Jenin raid, and again, any image, any testimony can be justified today in legal language. And this is why I stand with Palestine, because Israel's war is not a war on Palestinians. Israel's legal narrative and war is parasitic and it feeds on the very values that makes up the modern society. It's a war on truth. Israel has a very absurdist view to a very absurdist constructivist view. The Israeli narrative feeds on a very absurdist view that anything can be interpreted. Any image of mass destruction, mass killing, the Israeli raid in the Jenin hospital, the destruction of Jenin in 2002, everything can be interpreted, even if you have live footage of someone being sniped, shot down in the head. This is open to interpretation. There's no truth. I genuinely think Israel's war is a war on truth. And really, this is why I stand with Palestine, apart from my biases as an Arab neighboring Palestine.
Thank you, Shahd.
With Abdelghany, and I absolutely echo what has been said so far, in the sense that it is a war on truth that is inherently building on the biases of the Western spectator as well. And by that I mean that Israeli lawyers are very well aware, or perhaps intuitively aware, of the biases that will allow the Western spectator to empathize directly with their argumentation. And if I may say something, is to talk about the future. The only way for repair and the only way for us to overcome this, after having lived this for 5 generations on, after having been living in a place where the writings of Ghassan Kanafani and Mahmoud Darwish and the whole thing are establishing their life, like our history has seen this over and over and over again. It's 5th generation on of misery and plight. And with this being one of the most harmful and big episodes of slaughter, when you look at the numbers and the amount of misery caused this time, it is actually as big as a Nakba. And we're all living this collectively, living the trauma of our ancestors. And even personally, the most traumatic scene was when I saw people having to leave their homes. And if I have a message to say is, displacement is not an option. Self-determination of Palestinian people is a non-negotiable right. And the only way forward is accountability, reparations, and if I may use the words of Abdelghany, the truth, and stopping the distortion of the truth, recognizing the plight and the justice that stands at the heart of the Palestinian cause. To do that, the only way forward is also through political means. And in the past few weeks, we've all been chanting again and again, إن رحل صوتي ما بترحل حناجركم. If my voice is gone, then your chants will keep on moving on. The only way to put this logic to shame is for people of the global south and the global north to keep on putting the shame, that shame onto the logic of justice versus politics. The moments that I've been seeing in London in the streets are akin to the moments of the Vietnam War, the war on Iraq, and once again, people are going to the street and calling imperialism out, calling people who find virtue in power out. And we need to keep that happening. And this needs to be the moment where the narrative about Palestine changes. When we go to Europe, we no longer have to justify ourselves. And the moment where we start perceiving of healing after this level of trauma. Otherwise, there's no other way of repair. And I hope that we're still able to hold on to our dearest and most important weapon, which is hope. Thank you.
And again, last but not least, Maha.
Thank you, Atta. And I don't want to repeat what my colleagues have brilliantly said so far in their last words or concluding remarks, and mine would be inspired by the title of this event, actually. The narrative is shifting, otherwise we wouldn't have seen a few weeks ago in the highest world court lawyers pleading and explaining and contextualizing the crime of genocide as perpetrated by Israel in against the backdrop of an ongoing Nakba against the Palestinian people, colonization and apartheid. This recognition, again, is very important and is telling to the fact that the narrative is indeed shifting, regardless of the spaces, the forums, and it is an accumulation of all the efforts, incredible efforts by Palestinian civil society and movement and so forth. And the grounds of international law are also shifting. Otherwise, we wouldn't have seen the case that was brought by South Africa before the International Court of Justice. We wouldn't have seen the incredible and immense positive and even, excited reaction, let's say, for the lack of word right now, by the majority of the Global South in pursuing this case, not only for the Palestinian people and justice for the Palestinians, but also as a way, if I'm allowed to say it, to avenge historical and past and ongoing injustices against those who have been oppressed and those who have been denied their rights, their justices, by the very same system and world order that continues to oppress and persecute the Palestinians. But the only problem, like the narratives are shifting, the grounds are shifting, but the problem we're up against now is just like it is a war on truth, it's also a war of time. We don't have that much time anymore. We don't have the privilege of humoring and taking things one step at a time, especially at this moment. And 5 months ago, actually, if not a few years ago. So the law at the end of the day is one tool. It's not everything. We can't leave it, but we must make it better. We must advance it. We must bring it forward in order for it to be able to influence and to act the way that it should be acting. Thank you.
And that's what we ask for, a rules-based international order that applies equally, right? I guess we'll have to do a part 2 after Israel submits its first report to the ICJ and see where it goes from there. Thank you all. This has been a wonderful session with wonderful voices. It's wonderful seeing most of you once again and meeting new faces as well. You've all been brilliant, and I hope that we can do this again. Keep your voices heard. For the participants, thank you for sticking in, even though we've definitely went well over the time that I had expected. But this has been, I just couldn't stop these wonderful speakers from speaking. Thank you all, and until next time, and peace and justice in Palestine.
Thank you.
Thank you to the interpreters.
And yeah, thank you للمترجمين. شكرا كثير.
شكرا عطا، شكرا مترجمين.
Yes,
شكرا كل.
thank you. And thank you to TWAILR and the Masters of Israel Studies at Birzeit Universities as well as to the interpreters. Thank you.